The other case that I think is really important is a case called Maples versus Thomas, and notwithstanding the question presented, the question to me in this case is how much poor representation can one criminal defendant receive before it rises to the level of ineffective assistance of counsel? And this case arises out of Alabama, and in many ways, I think this case actually pulls together many of the strands of concerns that have been raised in prior cases involving ineffective assistance of counsel, which come out of Alabama. And so it's important to know the context of this case. Alabama is a jurisdiction that does not provide indigent criminal counsel for convicts in post-conviction proceedings. They also do provide counsel in trial proceedings in capital cases and in direct appeals, but they cap the attorney's fees that can be recovered at $1,000. And so what this means is that very often you have not very experienced attorneys who are working on capital cases in Alabama. In Alabama, you also do not need to have a unanimous jury verdict to impose the sentence of death. 10 out of 12 jurors are sufficient. So if you put all of that together, you get a lot of cases emanating out of Alabama, as Wood versus Allen 2 years ago, and Maples versus Thomas this year, in which Corey Maples went to trial with pro bono counsel, two very inexperienced counsel, at both the guilt phase and at the sentencing phase. The counsel failed to put on any evidence about the fact that he had been taking crystal meth and crack on the night of the murders, which might have suggested that he, under Alabama law, didn't have the mental capacity to be responsible. And at the sentencing phase, they put on no evidence about his bouts with depression, the fact that he had been suicidal, abandoned by his mother, abused, and the other kinds of mitigating evidence that might have helped at the sentencing phase. In fact, they were so overwhelmed at the sentencing phase that the attorneys themselves said to the jury, "We know it looks like we're stumbling around in the dark." So obviously he was sentenced to death, and then at the post-conviction phase, he actually seemed to hit the jackpot. He got two attorneys from Sullivan and Cromwell, a New York law firm, who agreed to represent him. They did all of his post-conviction work, and then they disappeared. And so when the clerk of the court sent a notice to the attorneys saying that his petition for post-conviction relief had been denied, they received a letter back from the firm saying, "Return to sender, left law firm." The circuit clerk didn't make any other efforts to contact the firm or to contact Mr. Maples in prison, and so the deadline for his appeal passed on post-conviction. In the habeas proceeding, when he learned that the deadline had passed, he was lucky again and got two attorneys. These seemed to be two very good attorneys, but the Alabama courts were very clear that he had defaulted, he had failed to appeal his post-conviction, his denial of post-conviction relief, and the 11th Circuit has also said he defaulted procedurally and he's unable to raise his claim of ineffective assistance of counsel. And so the court is going to have to deal with that issue coming out of Alabama.